Good evening. I will call this meeting of the Standing Committee on Government Operations to order. Today we are gathered to do a clause-by-clause review of Bill 20, Ombudsperson Act. Does committee agree to place that item as the sole item on the agenda? Thank you, committee. Any declarations of conflict of interest? Hearing none, we'll move on to our sole item of business, clause-by-clause review of Bill 20. Tonight we are reviewing Bill 20 Ombudsperson Act. Bill 20, sponsored by the Minister responsible for public engagement and transparency, provides for the appointment of an ombudsperson as an officer of the Legislative Assembly of the Northwest Territories. The bill establishes the mandate of the ombudsperson to investigate complaints about the administrative fairness of the government of the Northwest Territories practices in order to promote fair, reasonable, and equitable government administration. Some key matters addressed by the bill include requiring the Commissioner on the recommendation of the Legislative Assembly to appoint an ombudsperson, conferring powers and duties on the ombudsperson for the purposes of fulfilling the ombudsperson's mandate, setting out which GNWT departments, boards, and agencies, collectively referred to in the bill as authorities, will be subject to the ombudsperson's jurisdiction, setting out how members of the public may make complaints to the ombudsperson, and setting out how investigations are to be conducted by the ombudsperson. Bill 20 received second reading in the Legislative Assembly on June 1st, 2018, and was referred to the Standing Committee on Government Operations for review. To commence its consultation on Bill 20, the committee wrote to invite input from a broad array of stakeholders and organizations in the Northwest Territories, such as municipal governments, chambers of commerce, governmental organizations, and professional societies. Committee also wrote to Indigenous governments in the Northwest Territories to seek their input, and in particular to canvass their interest in accessing the services of the Ombudsperson on a cost-sharing basis in a manner similar to that provided for in the Yukon Ombudsman Act. The committee held 7 public hearings on Bill 20 in Inuvik, Norman Wells, Fort Resolution, Hay River, Betchico, Delo, and Yellowknife. As well, committee received 8 written submissions on the bill from the Yellowknife Chamber of Commerce, the Tlicho government, the Katlodichi First Nation, former MLA Miss Wendy Bizero, Mr. Colin Bale, the NWT Senior Society, the NWT branch of the Canadian Bar Association, and the City of Yellowknife. On behalf of committee, I would like to thank the communities who welcomed us on our travels and everyone who provided input on Bill 20. The details of the submissions received by committee and the nature of committee's deliberations will be addressed in our report, which will be tabled in the Legislative Assembly next week. As a result of committee's consultation, committee gave consideration to a number of amendments we believe will improve Bill 20, and we will be proposing a number of amendments to Bill 20 at this evening's meeting. I will now invite members of the committee to introduce themselves for the record, and then we will turn the floor over to the Honourable Louis Sebert, Minister of Public Engagement and Transparency. Mr. Nakamayak.
Good evening. Welcome, everybody. Herb Nakamayak from the Nukput.
R.J. Simpson, MLA, Hay River North.
Danny McNeely, Santu.
Kevin O'Reilly, Frame Lake.
And I'm Kieran Testo, the member for Cam Lake and chair of the Standing Committee on Government Operations. With me at the table are Committee Clerk Jennifer Franki-Smith, Committee Research Advisor Lee Selleck, and Law Clerk Glenn Rutland. And now I'll ask Minister Sebert to proceed with any opening comments you may have and to introduce yourself and your staff for the record. Mr. Minister?
Yes, thank you, Mr. Chairman. I am pleased to appear before the committee today to help review Bill 20, the Ombudsperson Act. With me today are Charlene Doolittle, Deputy Secretary to Cabinet, Mike Reddy, Legislative Counsel, Allison Anderson, Cabinet Policy Advisor, Richard Robertson, Director of Policy and Planning with Justice, and my Ministerial Special Advisor, Stephen Dunbar. Bill 20 represents a long-standing priority for members of the Legislative Assembly, as well as the government's general commitment to enhancing transparency and accountability. Ombudsmen serve as a check on government, monitoring its treatment of citizens and promoting accountability in public administration. Specifically, an ombudsman investigates whether the administrative decisions, recommendations, actions, or omissions of government authorities in relation to its citizens are improper based on principles of administrative fairness. Ombudspersons, are independent. As an officer of the Legislative Assembly, they have the freedom to offer honest criticism to the institutions they investigate. Ombudspersons are impartial. They are advocates for fairness. They are not advocates or agents for any party to a dispute. Investigations by an ombudsperson are confidential. The information collected by the ombudsperson will not be subject to disclosure under our access to information laws, and the ombudsperson cannot be compelled to provide information in proceedings of a judicial nature. Further, ombudsperson investigations require a credible review process. The bill sets out what the ombudsperson can investigate and provides the ombudsperson with wide powers of investigation. These powers include the discretion to resolve matters informally, the authority to make findings and develop recommendations to resolve the unfairness and improve administrative practices, and the ability to report matters to the Premier, the Legislative Assembly, and the public. Mr. Chairman, I look forward to responding to any questions the committee may have. Thank you.
Thank you, Mr. Minister. One more housekeeping rule before we begin the formal hearing. In accordance with Rule 93 of the Rules of the Legislative Assembly, the rules and procedures of the Legislative Assembly shall be observed in committees so far as they're applicable. For this evening's clause-by-clause review, any regular member attending may speak to the general comments on the bill. Committee members will be allowed to speak up to 10 minutes on any motion to be decided by committee. Does committee have any general comments or questions before we begin the clause-by-clause review? Mr. O'Reilly.
Thanks, Mr. Chair. I've reviewed the bill, and I want to commend the department for the work that's been done here. I think it's pretty good. I do have a couple of specific issues. And I guess it's 17(3) of the bill says that the ombudsperson shall not investigate conduct occurring before the commencement of this act. And I guess I'd like to get some rationale for that part of the bill. Thanks, Mr. Chair.
Mr. Minister.
Yes, we did turn our minds to this section, and it is important, and we have a series of concerns about it. One of the things that we're concerned about is that we feel as though if the complainants could raise complaints from long ago, that the ombudsperson would be faced with an insurmountable volume of complaints. I don't know what date they could go back to, but in theory, I suppose a long time. And those complaints may be difficult to investigate. And we're concerned that initially when this office is set up that the office might be overwhelmed, and also the costs might become overwhelming also. We do note also that our sister jurisdiction of the Yukon expressly prohibits the investigation of activities prior to the commencement of their act, and we were aware of only one jurisdiction, which is British Columbia, that allows its ombudsperson to investigate conduct predating commencement of the act. So we understand that we don't have to be like everybody else. We don't, but we were quite concerned about the volume of complaints that might arise. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. O'Reilly.
Thanks, Mr. Chair. I guess I could foresee, though, where if this person can only investigate conduct occurring after the commencement of the act, they're going to be sitting there twiddling their thumbs for maybe, I don't know, a year or something, until something happens, and then somebody could make a complaint. So I'm not sure this is sort of what the public expects. Look, there's probably going to be some folks that have had concerns or issues that have arisen over a period of time, and maybe some of it's been as recent as the day before. The bill could or the act could receive assent. So to have this sort of hard cutoff period, I'm not sure that that's what the public expects. And as I say, I think this person could be sitting around doing nothing for quite a while. If a complaint comes in to the office, anything leading up to that complaint then that happened before the bill gets assent, is that outside of the scope or the mandate of the ombudsperson? Is that the way this would be interpreted? Thanks, Mr. Chair.
Mr. Minister.
Yeah. You've raised an interesting issue as to something that might be ongoing, I suppose, and I don't know. Do you have any thoughts on that? So an ongoing concern, if it did have a hard cutoff date, I suppose that if the matter was still an administrative failure or a concern after the act came into force, certainly that would be could be subject to an investigation by the ombudsperson. If the matter was completed completely before the act and there was a cutoff date, I would say it could not be. It's an interesting question as to ones that were sort of ongoing between two periods of time. Maybe Mr. Reddy can add something to that.
Mr. Reddy.
Thank you, Mr. Chair, and I don't mean to step on the toes of the law clerk here, so by all means, if he has any comments in addition to mine, it's an interesting question. I am drawn to Section 15, and I look at that word aggrieves. So in MLA O'Reilly's example here, I think an argument could potentially be raised that was something that happened prior to the commencement of the act, but that aggrieves, i.e. is of an ongoing nature. Yeah. There very well may be the ability there for the mandate of the ombudsperson to step in.
Thank you.
Okay, thank you, Mr. Reddy. Thank you, Mr. Minister. Our interpretation is the same at this side of the table. Mr. O'Reilly?
Thanks, but look, I'm not a lawyer. It's my understanding, though, that somebody can only go to this office if they've appealed everything, they go through all of the processes, which could take a number of months. But if any of that was going on before the bill receives assent, it's outside of the scope of the mandate for the ombudsperson. Is that the right kind of interpretation? And again, this person could be sitting around for months while people are waiting for all of this stuff to get sorted out in appeals and so on. I'm just worried about this hard date. Thanks, Mr. Chair.
Mr. Minister?
Well, if the matter was, let's say we did have a hard date of, I don't know when this would come into force, let's say, I don't know, January 1st, and the matter arose before then and was completed before then, I see. You're wondering about an ongoing process in front of an administrative body that would extend into the that commenced before the January 1st and continued afterwards. It would seem to me that from what we've heard, that it's a possibility that could appear in front of the ombudsman. If that's what I heard from the other lawyers in the room. Is that right? Okay.
Mr. O'Reilly?
Can I ask questions of our law clerk then? Or I just don't know how this is going to work.
Yeah, you may.
Okay, can I get advice then from our law clerk about as I understand it, you can only go to the office, the ombudsperson, if all of the appeals and so on are exhausted. If any of that process has started before, or even the incident that led to it, before the act receives assent, is it within the scope of the ombudsperson to investigate that complaint?
Mr. Rutland?
There's an interpretation where the answer would be no. Regardless of a time where someone may be aggrieved, the current provision of the act says it shall not investigate conduct occurring before the commencement of this act. So, in fact, if it's the specific conduct was before the commencement of the act, there is an interpretation that could say it is out of the scope, even if there is an ongoing appeal process. Now, if someone was to complain about an appeal process that was taking place after the commencement of the act, that may be within. And in terms of having to exhaust all aspects of an appeal, there is a provision where if it would be unreasonable to expect someone to pursue that recourse, the ombudsperson can. So you don't necessarily have to exhaust it. An example is that if you end up in court, technically the right of appeal goes all the way to the Supreme Court of Canada. It might be unreasonable to expect someone to do that. And the ombudsperson could step in before that's done.
Mr. O'Reilly? You have 50 seconds left.
Yeah, I think this is problematic and is gonna cause problems. And sorry, this isn't a question for my colleagues here. This is gonna cause a problem. I think there's a lot of expectations that this is going to be an avenue for folks to resolve things. There might be a bump at the beginning, but this, I don't think, is fair and is gonna cause us problems in terms of the expectations that have been raised about this bill and what it can do. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Minister, do you want the last word?
I realize I'm in the question answering business, not the question asking business here, but and I'm not expecting really an answer, but I'm wondering if Mr. O'Reilly, whoever has been thinking about this, is thinking of any date or just leaving it open back to whatever, 1999, 1967, 1867.
Okay, thank you, Mr. Minister. We'll leave the questions to committee, but there certainly are amendments being proposed tonight, as I mentioned in my opening comments. We'll now go to Mr. McNeely.
Yeah, thank you, Mr. Chair. As the minister said and others agree, this is going to be an interesting one that our colleague, Mr. O'Reilly, raised here, but I just throw out another note, I would say, for consideration. If you go to the summary, the summary of the act kind of initiates towards the investigation of a complaint. And if the minister says, okay, well, the assent date's going to be January the 1st, but the complaint was submitted prior in November, I would almost say that would be grounds to say, yes, this wouldn't apply, because the investigation of the complaint was initiated in November, not after the assent. The investigation itself is ongoing on a transitional period overlapping the date, but the complaint itself was lodged prior. So I just point that out.
Mr. Minister?
I think it's essentially the same concern that Mr. O'Reilly raised. I don't think I have anything additional to add. I mean, if the complaint arose clearly from events and before the magic date, whether it's January 1st or some other date, it seems to me, under our proposal, it would not be before the ombudsman. Thank you.
Mr. McNeely?
Yeah, I understand where the concerns are, but I just mentioned that, and I think if we accepted the ombudsman's duties to act on complaints prior to assent, I think we're really opening the doors for a lot of complaints. Who knows, it might go as far back as the 13th Assembly. And it would just, I don't think it'll be right moving forward with the new bill when it comes into law.
Mr. Minister?
I just don't think that there will be much time for the ombudsman to twiddle his thumbs, as was mentioned in a concern earlier, because I think once this gets out there that complaints, complaints that even if we have a cutoff date, I think they will start coming in, and I don't think the ombudsman is going to be lacking for work. Our real concern is, in fact, the opposite, is that they're going to, should there be a much earlier date from which complaints could be commenced, we're more concerned that they're going to be overwhelmed. Thank you.
Mr. McNeely?
Nothing further, Mr. Chair.
Thank you, Mr. McNeely. Minister, this seems to be grabbing committee's attention, so I'm going to propose some dates for an exemption period, just to canvass your potential interest in this. So most limitation periods in the NWT for court actions is 6 years. Would that sort of time backwards looking date be acceptable to the government in this matter? Mr. Minister.
I would have the same concerns. It's certainly a better idea than 1999. I would have to take it up with my cabinet colleagues, but really, I mean, most laws are not retroactive, and I just am, I mean, this is a new piece of legislation which we're bringing in quite properly, and I just don't like the idea of looking back. And I don't think that as I said earlier, the ombudsman is going to be lacking for work. Thank you.
Thank you, Mr. Minister. Well, committee, I think this is well-tread ground, so we will move on to any other general comments. Okay, hearing none, committee will move into the clause-by-clause review. Does committee agree? Thank you, committee. We'll defer the title of the bill until the end and begin with consideration of the clauses. There are 46 clauses and one schedule in the bill. Does committee agree to consider the clauses in groups? Thank you. Committee, please turn to page 5 of the bill. Mr. Simpson.
Thank you, Mr. Chair. I move that the English version of Bill 20 be amended by A, striking out ombudsperson and substituting ombud wherever it appears in the bill, and B, by striking out ombudspersons and substituting ombuds wherever it appears in the bill. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order to the motion. Mr. Simpson?
Thank you. I'll just be brief here. Ombudsperson, it doesn't really roll off the tongue. I mean, we've had difficulty already in this meeting. I saw a few people stumble over it. I think moving forward, I think ombud is a good, solid name. We won't be the only jurisdiction as well that uses ombud. And I think it's clear that it's a person who will be doing this job, so it's a bit redundant. So I'm happy to move this motion to use ombud versus ombudsperson. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question.
Question's been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment? Minister Sebert.
Yes.
Thank you, Minister. The minister concurs. The amendment, committee to the clause as amended. Because clause 1 is amended. No, sorry. What's the title? There we go. Thank you, Minister Sebert. To the amendments of the English version of the bill. Thank you. Clauses 1 through 5. Does committee agree? Clause 6. Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 20 be amended by deleting subclause 6.3 and substituting the following. 3, if the Legislative Assembly is not sitting, the Commissioner, on the recommendation of the Board of Management, may suspend the ombud for cause or incapacity, and the suspension shall remain in effect until the conclusion of the next sitting of the Legislative Assembly. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. This limits the length of any suspension and until the next sitting of the House. Before, that was sort of unaddressed in the original bill. So it's just to add some clarity. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? All those opposed? Motion is carried. Does the minister concur with this amendment? Minister Sebert.
Yes, we concur with this amendment.
Thank you, Minister Sebert. To Clause 6 is amended. Does the committee agree? Thank you, committee. Clause 7. Does the committee agree? Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 20 be amended by adding, I move that Bill 20 be amended in that portion of the sub-clause 7.3 preceding paragraph A by striking out the speaker and substituting the Board of Management. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair. This adds a bit more, it changes the authority for appointing an acting ombud to the Board of Management rather than the Speaker, just adding a few more voices in there so there's a bit more accountability. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion carried. Minister Sebert, do you concur?
Yes. Concur.
Thank you, Mr. Minister. To Clause 7 is amended. Does the committee agree? Thank you, committee. Clause 8, Mr. Simpson.
Thank you. I move that Bill 20 be amended in subclause 8.1 by striking out the Speaker and substituting the Board of Management. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion's in order. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur?
Concur.
Thank you, Mr. Minister. To Clause 8 as amended. Does the committee agree?
Agreed.
Thank you, committee. To Clauses 9 through 14. Does committee agree?
Agreed.
Thank you, committee. Clause 15. Does committee agree? Mr. McNeely.
Thank you, Mr. Chair. I move that Bill 20 be amended by deleting subclause 15, brackets 1, and substituting the following. 15.1, brackets 1, the mandate of the ombud is to investigate and decision or recommendation made or any act done or omitted by an authority or by an officer, employee, or member of an authority in the exercise of any power or duty conferred on that person or body by any enactment that A, brackets, relates to a matter of administration or implementation of a policy, and B, aggrieves or may aggrieve any person or any body of persons in the person's or its personal capacity. Thank you.
Thank you, Mr. McNeely. The motion is in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. I support this motion. A lot of legislation is a little dense and difficult for the general public to read, and this helps clarify a very important part of this legislation, which is the mandate of the ombud. And it also refers to policy, which I don't believe is included in the original. Even though it's clear, a fulsome reading of the bill makes it clear that the ombud has authority to make recommendations as to policy. There's no doubt about that. This just makes it clear to the general public as well. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question has been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
No, we don't concur with this motion.
Thank you, Mr. Minister. As the minister does not concur, this amendment is defeated. To clause 15.
Agreed.
Thank you, committee. To clause 16. Mr. McNeely.
Chair, I move that Bill 20 be amended by deleting subclause 16 brackets 2. Thank you.
Thank you, Mr. McNeely. Motion's in order to the motion. Mr. Simpson.
Thank you, Mr. Chair. I support this motion as well. This removes the power of the Executive Council to use the Ombudsperson for its own internal purposes. There's already a mechanism in government, the Internal Audit Bureau, which can do this. The Ombud is for the people, it's not for the government. The government has the resources at hand to examine itself. I mean, it better. You know, we don't want the Executive Council tying up the Ombud's time as well. So I think that it makes sense to remove this. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
Yes, we concur.
Thank you, Mr. Minister. To clause 16 as amended. Does committee agree? Thank you, committee. Clause 17. Nope. Oh, sorry. Motion, okay, sorry. Okay, returning to clause 16, Mr. McNeely.
Thank you, Mr. Chair. I move that Bill 20 be amended by adding the following after subclause 16 brackets 2. Brackets 2.1. A municipality or an Aboriginal government may at any time refer the matter relating to the administration of that body to the Ombud for investigation and report, and that Ombud may, A, brackets, subject to subsection brackets 2.2, investigate the matter referred, and brackets B, report back to the municipality or Aboriginal government as the Ombud considers appropriate. Next, brackets 2.2, the costs and expenses incurred by the Ombud related to an investigation and the report carried out under subsection brackets 2.1 shall be paid by the municipality or Aboriginal government that referred the matter to the Ombud. Thank you.
Thank you, Mr. McNeely. Motion is in order. To the motion, Mr. Simpson.
Thank you. I support this motion as well. It adds a clause similar to one in the Yukon, which allows Indigenous governments or municipalities to contract out their ombudsperson, the ombud essentially, if they'd like. There's no, this doesn't give the ombud authority to go into and examine Indigenous governments on its own merit or on its own. It only allows the governments to reach out, the municipalities to reach out to the ombud and invite them to come and come have a look at their operations. And it's on a cost recovery basis, so I think everything makes sense, and I support this motion. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
Concur.
Thank you, Mr. Minister. Minister concurs to the motion, to clause 16 as amended. Does committee agree? Thank you, committee. Clause 17. Yes, Mr. McNeely.
Thank you, Mr. Chair. I move that Bill 20 be amended in subclause 17 brackets 2 by striking out, it would be unreasonable to expect the complaint to pursue that recourse, and substituting, it would have been unreasonably to expect or have expected the complaint to have pursued that recourse, and the time for the exercise of that right be appeal, comma, object or apply as expired. Thank you.
Thank you, Mr. McNeely. To your motion, you said complaint. Is it complaint or complainant?
Complainant.
Okay, thank you for the clarification, Mr. McNeely. With that in mind, motion is in order to the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur with the motion?
Yes, concurred.
Thank you, Mr. Minister. To clause 17 as amended. Does committee agree? Mr. Nakimayak.
Thank you, Mr. Chair. I move that Bill 20 be amended by deleting subclause 17 brackets 3. The Ombudsman may investigate any matter within the Ombuds's mandate that occurred after April 1st, 1999.
Motions. Motion is in order, but I just want to give the clerk a minute to speak to Mr. Nakimayak. Mr. Nakimayak.
Thank you, Mr. Chair. I have a couple of pieces of paper here. So I'd like to withdraw that last motion, but I'd like to move that Bill 20 be amended by deleting subclause 17 brackets 3.
Thank you, Mr. Nakimayak. The motion's in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair, and this is the subclause that caused a lot of discussion prior to getting into the detail here. I just saw 3 lawyers and a legislator with extensive experience reading legislation try to figure out what it meant. To allow that subclause to go through is just poor drafting. I don't think there's 2 ways about it. And that's in addition to the fact that it may deny people the ability to access the ombudsperson to deal with a case of administrative unfairness. And I know the minister was worried that there might be a deluge, if that's the word, of complaints. I mean, I have a little more faith in our government than the minister, perhaps. I don't think there's going to be a landslide of complaints coming through that is just going to bury this office. And I think that if we get an ombudsperson, they're going to be a qualified person. They're not going to be someone who just gets a complaint from 50 years ago and figures they have to investigate it regardless. This person has the right to look at individual complaints and investigate them or not on their own merits. So for those reasons, I support the motion. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question.
Question has been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
No.
Thank you, Minister. Minister does not concur. The amendment is defeated. To clause 7 as amended, committee. 17, sorry. My apologies. To clause 17 as amended. Committee, clauses 18 through 21. Well, 18 to 21. It's agreed? Okay. Clause 22, Mr. Nakimayak.
Thank you, Mr. Chair. I move that Bill 20 be amended in subclause 22 brackets 1 by adding the following after paragraph D. The complainant has abandoned the complaint, brackets I, by failing to advise the Ombudsman of the current contact information in which the complainant can be contacted, or by failing to respond after a reasonable number of attempts by the Ombudsman to contact the complainant verbally or in writing. Thank you, Mr. Chair.
Thank you, Mr. Nakimayak. Motion's in order. To the motion. Mr. Simpson.
Thank you. I think this was probably just overlooked when the bill was drafted. It's just good housekeeping, it's good drafting, so I approve this. I'd support this motion. Thank you.
Thank you, Mr. Simpson. To the motion.
Question.
Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur?
Yeah, yes, we do concur. I'm sorry, this is subclause 22.1, right? I thought I heard a different number.
Yes, 22.
22.1? Okay, I thought I heard a different
Okay,
number.
sorry, it is 22 brackets 1.
Yeah.
Do you still concur, Minister?
Yes, we do.
Okay, thank you,
Thought I-
Thank you, Mr. Minister. To clause 22 as amended. Does committee agree? Thank you, committee. To clause 23, Mr. Nakamayak.
Thank you, Mr. Chair. I move that Bill 20 be amended by deleting clause 23 and substituting the following referral of complaint 23. The Ombuds shall not investigate any matter that falls within the mandate of the Languages Commissioner, the Information and Privacy Commissioner, the Conflicts of Interest Commissioner, the Chief Electoral Officer, the Director of Human Rights, or the Equal Pay Commissioner, unless that Commissioner, Director, or Officer agrees. Thank you, Mr. Chair.
Thank you, Mr. Nakamayak. Motion is in order. To the motion? Question has been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
Yes, we concur.
Thank you, Mr. Minister. To clause 23 as amended, does committee agree? Thank you, committee. To clause 24, Mr. Nakamayak.
Mr. Chair, I move that Bill 20 be amended by adding the following after subclause 24 brackets 5. Bracket 6, if during or after investigation, the Ombud is of the opinion that there is evidence of any breach of duty or misconduct on the part of the administrative head of an authority, the Ombud shall refer to the matter to such other persons as the Ombud deems appropriate and may continue with the ongoing investigation. Thank you, Mr. Chair.
Thank you, Mr. Nakamayak. Motion's in order. To the motion, Mr. Simpson.
I believe this clarifies the process, just clarifies the process for investigations where the head of an authority is subject to the complaint, or is the subject of the complaint. So it's again, sort of a little, just a piece of housekeeping essentially. So I support this. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question.
Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur? Yes. Thank you. Mr. Minister, to clause 24 as amended. Does committee agree? Agree. Thank you, committee. Clauses 25 through 31. Does committee agree? Agree. Thank you, committee. Clause 32. Mr. Nakamayak.
Thank you, Mr. Chair. I move that Bill 20 be amended by, in clause 32 by striking out, notify both the complainant and the authority of the decision and the reasons for the decision, and substituting, notify in writing both the complainant and the authority of the decision and the reasons for the decision. Thank you, Mr. Chair.
Motion's in order. To the motion. Apologies. People are trying to call me. Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur?
Concur.
Thank you, Mr. Minister. To clause 32 as amended. Does committee agree? Thank you, committee. Clause 33. Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 20 be amended in that portion of subclause 33(1), preceding paragraph A, by striking out to the administrative head of the authority and substituting to the administrative head of the authority and the minister responsible for the authority. Thank you, Mr. Chair.
Motion's in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. This just requires the Ombud to report the decision and the reasons for it to the minister as well as the head of the authority, like essentially the deputy minister. It's consistent with section 35(1), which requires the Ombud to report any modified decisions to both, and it ensures that the language related to the recommendations is consistent with the mandate. Thank you.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur?
Yes.
Thank you, Mr. Minister. To clause 33 is amended. Does committee agree? Thank you, committee. Clauses 34 through 36. Does committee agree? Thank you. Clause 37. Mr. Simpson?
Thank you, Mr. Chair. I move that Bill 20 be amended in subclause 37(1) by striking out the Ombudsperson may submit a report to the Premier and subsequently may submit such a report to the Legislative Assembly, and substituting the Ombud may submit a report to the Premier and the Legislative Assembly. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion's in order to the motion. Mr. Simpson?
Thank you, Mr. Chair. This change just ensures that if the Ombud is submitting the report to the Premier, it also will go to the Legislative Assembly. I think that's a good tenet of consensus government that we all know what's going on. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion.
Question?
Question's been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
No.
Committee, the minister does not concur. The amendment is defeated to clause 37. Does committee agree? Thank you, committee. Clause 38. Does committee agree?
Agreed.
Okay. Clause 39. Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 20 be amended in subclause 39(3) by striking out "or in any proceeding of a judicial nature" and substituting "or in any proceeding of an administrative, judicial, or quasi-judicial nature." Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion's in order to the motion. Question's been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur?
Yes.
Thank you, Mr. Minister. To clause 39 as amended, does committee agree? Thank you, committee. Clauses 40 through 46. Does committee agree? Thank you, committee. To the schedule, does committee agree? Mr. Simpson?
Thank you. I move that the schedule to Bill 20 be amended by deleting item 5. Thank you.
Thank you, Mr. Simpson. To the motion, motion's in order to the motion.
Question?
Question's been called. All those in favor? All those opposed? Motion carried. Mr. Minister, do you concur?
Yes, we concur.
Thank you, Mr. Minister. To the schedule as amended, does committee agree? Thank you, committee. We will now return to bill number and title, Bill 20, Ombudsperson Act. Does committee agree? Mr. Simpson?
I move that the English version of the title to Bill 20 be amended by striking out Ombudsperson Act and substituting Ombud Act. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion, motion's in order to the motion. Mr. Simpson?
Thank you, Mr. Chair. This brings some consistency now that we've changed all the references from Ombudsperson to Ombud in the Act. We're changing the name of the Act to Ombud. Just like every other motion that we've made here today, makes perfect sense. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion?
Question?
Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur?
Yes, we concur.
Thank you, Mr. Minister. To the title as amended, does committee agree?
Agreed.
Thank you, committee. Does committee agree that Bill 20 Ombud Act is now ready for as amended? Oh, sorry, is now ready for consideration in committee of the whole as amended and reprinted. Yes, Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 20 Ombud Act be reported to the Assembly as ready for consideration in committee of the whole as amended and reprinted.
Thank you, Mr. Simpson. Motion's in order. Motion's on the floor. To the motion.
You can put the question.
To the motion. I cannot put the
Question?
question. Thank you, Mr. Simpson. Question's been called. All those in favor? Any opposed? Thank you. Motion carried. Bill 20 Ombud Act will be reported to the Assembly as ready for consideration in committee of the whole as amended and reprinted. Thank you, Minister, and thank you to your officials. And thank you to members of the public who joined us tonight. I would just add a final note. Committee had some motions that did not achieve concurrence at this hearing tonight. Those motions may be returned in committee of the whole for further debate. And I wanted to make sure the minister and his staff are advised of that. Thank you very much again. Minister, would you like to comment?
Yes, thank you. I know that you've done a lot of work on this matter, including going out to the public in was it 6 or 7 communities throughout the Northwest Territories. I know that the most contentious matter seems to be the issue of subsection 17.3, but, you know, we have limitations in much of our legislation, whether it's, you know, all sorts of legislation, and sometimes you do have to fix a date, and I'm saying this legislation should speak from the day that it comes into force, rather than looking at some date in the past. Even if you look at dates in the past, whether 1 year, 6 years, 30 years, there may be people that are cut out. But as I say, there's lots of legislation here and elsewhere that does impose limitation periods. So we're suggesting, again, that this act speak from the date it comes into force. Thank you.
Thank you, Mr. Minister. It's a preview for the coming debate, I'm sure. Committee is also, one amendment that didn't make it to the floor tonight is a proposed preamble, which your office has been advised of, and as that drafting process continues, we'll keep you advised of that. Mr. Minister.
Can you advise us when you'd have that to us? Because I can't make, even if it had been before me tonight, I couldn't have concurred with it. I'd have to take it to Cabinet.
Yeah, thank you. We will provide it ahead, in due course, ahead of the Committee of the Whole hearing. With that, Committee, I will adjourn us for the evening. Thank you again to everyone for your due diligence and attention to this important piece of legislation. Good night.